A very good morning and a very warm welcome, and today we are going to discuss one of the most important areas when it comes to law, that is intellectual property law, with our today's program Law and Order. So simply to do the honors with us, we have one of the most important personality when it comes to the intellectual property law, and she is Madam Aparajita Aryadasa, attorney at law, and she is the chairperson for Lanka Intellectual Property Organization, an advisor for the Bangladesh Intellectual Property Development Program, and one of the best 10 researchers in the world. Thank you very much, madam, for accepting our invitation and taking part in today's program.
Thank you too.
Right. Okay. So to move in discussion with today's topic, intellectual property, simply can you explain what is intellectual property?
Yeah, when you talk about intellectual property means intellect. The properties which are born by the human intellect. But there's a difference between the human intellect and the artificial intellect.
Right.
So, like copyright, trademarks, trade names, industrial designs. When you talk about copyright, of course, it covers the music, the photographs, the writings, books, pamphlets, dancing, singing, everything. So, actually there are two categories, main two categories, copyright and industrial property. When you talk about industrial property, it is divided into a couple of categories. One is trademarks, the other one is trade names, industrial designs, trade secrets, all are intellectual property. And there's a bit of a different categorization as neighboring rights, that is collective rights. It is bit different to copyright, but it's just like, you know, similar to copyright. That's why they are called neighboring rights, neighbors of copyright. Right? So these are like dancing, the performers' rights, broadcasters' rights, and sound recorders' rights. They come under collective rights.
Collective rights. So what is the law that governs intellectual property here in Sri Lanka?
Yes, law is actually the Intellectual Property Act number 36 of 2003. So that is the act which governs the intellectual property rights. So we have actually a comprehensive and wholesome legislation, I must say. There are gaps everywhere. Any law has a gap. That is the act actually.
Right. Okay. So a little bit moving in deep with today's topic, and simply can we expose what is copyright?
Yeah, copyright is actually the right to copy. So copyright covers writings, photographs, simply literary, artistic and scientific work. So if the work comes under literary work, like books, poems, songs, whatever, pamphlets, brochures, whatever, written work covers under copyright. Artistic means all the artistic work, art, sculpture, drawings, whatever comes artistic covers under artistic work. Scientific work is like, you know, computer programs, architectural work, sometimes industrial designs come under scientific work, sketches, drawings, scientific drawings. So those come under scientific work.
Right. So let's come to a scenario. If I'm a music composer, how can I protect my rights?
Yeah, if you are a composer, of course you have the right for your composing. As an example, if I am a composer, I write my interludes, I write my sarigama in a piece of paper. That particular interlude belongs to myself, that particular compose belongs to myself. So the author is myself, but the thing is there's a small differentiation of authorship and the ownership. Authorship means the person who creates it. Right? Once you sell it, now you ask me to do a song for you. I mean, composing for one of another person's songs. So I make the the interlude, or I make the sarigama, the tune. So if you pay me and if you take the rights, the selling rights or the economic rights from me, economic right goes to you, the ownership goes to me. The author is myself. So authorship doesn't change, but the thing is ownership will be changed.
So what is the difference there? How can when it comes to a legal scenario, can you just explain us a little bit?
Yeah, when you talk about the legal scenario, owners are having the economic right. So whatever the things, actually copyright, just like another right, just like another property. Intellectual property also can be exploited. Exploited means you can either sell, you can lease, you can assign, you can do whatever you want. So likewise, the owners can do whatever they want, but authors have to be mentioned.
Right.
Right? So when it comes to a song, actually there are a lot of discrepancies in this particular area even now with the composers and with the film directors and with singers, lot of problems. So when it comes to a song, there are a lot of people involved. Right? Now song, of course, you can't just have the tune. So there should be a singer. There should be a producer. So in this scenario, this comes as a collective right, collective work. So the person who takes them in and collect them is the owner. That means the producer.
Right.
So that is the law.
Okay. So if I'm selling my music to you, madam, and you're buying that, and I'm claiming, why didn't you insert my name or publish my name? So will that be sufficient in order to take a legal action?
That is sufficient. That is called moral rights. Moral right is that the author is the one who creates. So I am entitled to have my name in my creation. No matter the owner, ownership will be with the other person or with whoever, but my name has to be mentioned there.
Right. So is there any limitation for the economic rights once it is sold? Can we impose?
In the sense?
Like, for example, I have written a book, I'm just selling it to you, and you're just paying a certain amount of money, and you're just making millions of copies, but I expect that you will make only hundreds or thousands of copies. So you are making a huge economic benefit. So can I claim that what I gain is insufficient?
Yes. The thing is like, it just, now as an example, I write a book. I publish couple of copies. That means counterfeiting, copying. Copying for economic purposes is a wrongful act. It's unfair competition. If you get a economic benefit out of my thing, anyway you are doing you have done the wrong thing. So it is called unfair competition. So I can take legal action against
actions against. So most fruitful discussions. And when it comes to this intellectual property, you might experience that certain other areas combine, counterfeiting and taking economic benefits more than that we expect. This is not simply one such area, but it combines each and every other aspect. So another scenario, madam, right? You have written a book. So for a certain study purpose or to distribute with 5-6 people, I just take photocopies, but you have stated in front, no photocopies, electronic, print media or such things, the statements that is made in front of the books. So what is the consequence? There can't be even photocopy for a study purpose.
No, the thing is, there's a principle called fair use. Fairly you can use. Actually this law is very beautiful law, and it's very fair. Actually I love that subject. So fair use means for study purposes, so for archival purposes, for teaching purposes. Actually how many books we photocopy. I mean nowadays we cut, we copy. So for studying purposes you can definitely take for copies. Even 10 copies are fine, because you are not having an economic benefit of this. You are just, you just want to, read it and understand and do your research. So it doesn't matter. It is the exemption.
Exemptions.
Yes.
Right. So with that copyright things, we'll move a little on to industrial area. So can you just explain that industrial arena as well?
Yes. Industrial property means trademarks, or simply in the business norms it's called the logos or brand names, brands. So there are millions of billions of brands in the world. The beauty of this trademark law is once you have a proper trademark registered under the sun, it is under the sun, you have a exclusive rights and exclusive monopoly against the whole world. That's what the one of the cases say. It's you have the exclusive monopoly against the whole world. So when it come to trademarks, once you register it, every 10 years you have to renew it. You have a lifetime protection for your trademark, and also when you calculate your income or calculate your turnovers or capital, share capital, this matters a lot and it has a value.
Right. So can't we sell those rights, like even copyright, like industrial thing, can't we sell?
We can. Actually, trademarks usually people don't sell. Right. What they do is that they assign the trademark for franchise purposes. Now, as an example, can I use these trade names? Can I use?
Better to be in general.
Okay, fine. So imagine you have a brand XYZ, right? So you own that brand. It's an international brand and it's popular in everywhere. So you can sell it to a company, not sell actually. Usually it's not advisable to sell a trademark. Selling means you give it exclusively to other person to exploit that trademark. What the normal businesses, I mean the multinational companies do is that they will franchise, they will license the trademark to that particular region. I mean if it is Sri Lanka, I will be having the franchise, I'll be the franchise agent who is having the power to exploit that particular trademark.
Right. As the authorized personnel, I can manipulate in the country.
You can use it, distribute it, and you can, sometimes you can license it likewise.
Right. So, ma'am, when it comes to those trademarks and brand names, simply there is a brand name, simply XYO, simply we can take, and there's a slight change even to the name. It's XYY, or even for that particular logo, it's a circle with a green color and 2 black dots, and I'm inserting 3 black dots. So sometimes people might misunderstand the brand, how that the law applies there.
Law in the sense, it's a very strong law, and there are a lot of held cases in Sri Lanka and very stringent legislation. No, you can't. Because similar names you can't use, because the consumer will be misled. If the consumer is misled, you can't use that trademark or trade name. But anyway, the intellectual property office will never allow to register that trademark.
So what is the, if I'm putting up a small business, so I need to have some trademarks and those things, how can I properly follow the proper procedure in order to register my thing?
Yes, if you have a logo, actually logos have to be admissible. Admissible in the sense, it can't be a similar trademark, it can't have common names, and there are common names like mangosteen. You can't put a trade name as mangosteen, but you can have a mark, right? So similar names or inherited names or names of people or flags, you can't put them as trademarks. But if it is a novel, thing, novel colors, if it is a combination of colors, stripes, you can actually register it in the National Intellectual Property Office. My proper advice is get the proper advice from a proper expert. Otherwise, it will be rejected after about 3 years.
3 years. So expert as in, man, can you just explain the
Expert
role?
in the sense a person who knows intellectual property very well.
A counsel might be. There are certain people.
Maybe who has, you know, studied, who has expertise in this subject.
That means they will advise in us in our business, the trademarks, how they are admissible in the sense like.
Yes, yeah.
Right. So will it consume a certain time period? As you said before, it's 3 years, might be rejected after 3 years. Is there a time period?
Time period in the sense there are classes as per the classification. This is called nice classification. There's a time period for the trademark, but the thing is like for the procedure. Now, yeah, as an example, imagine bicycle parts. You have a bicycle bicycle shop, and you are going to register your trading company in a separate trademark. So you are under one class, spare parts or something. So if I may make legal business, I'm a lawyer, you know, so legal business, so service industry. Likewise, classes are there. So once you put your registration, I mean the application along with your logos, it takes some time for the search. So once the search is done, the National Intellectual Property will decide whether to take it or not, reject it. So rejection can be avoided if you take proper advice from an expert. Actually, this has to be an expert, otherwise it won't be successful.
That means with proper advice and proper guidance, when we are proceeding, we won't get in trouble, and we can complete our process formally without putting ourselves in burden.
Correct.
Right. So simply move into the other stage. I have my own creation. I need to obtain a certificate, simply a patent. What that procedure is? Actually,
patent, of course, you have to have a couple of things, but in Sri Lanka that is not very stringent, but when it comes to American patents and European patents, it's really hard. You have to have novelty. Novelty should be there in your product. Inventive step. Invention should be having inventive steps, no? Inventive step and industrial applicability. These three elements should be fulfilled for you to get a patent in Sri Lanka. So there are a couple of procedures. You have to file the application, and you have to put your claims, you have to do abstract. So it's a bit of a difficult task unless you get the help from a super expert who can draft patents. So ordinary people can't do, because I have seen a lot of scientists have failed by doing this, because it's you know, it's an interdisciplinary subject where you get yourself involved in legality as well as the science. Now imagine you want to patent a process. Actually, process and a product can be patented. You want to patent a chemical process. So unless the person, imagine myself, so I have a degree in chemistry, so I know how that to be done. So you have to have a expert knowledge to draft that particular document. So you have to go for a person who can do that drafting. Otherwise, even if you are a scientist, you may not be able to get into that track and get your patent done. That has happened to a lot of scientists in Sri Lanka. It's because of that, because that is a combination. Patent is a combination. Patent drafting is a combination of both science and law, or engineering and law. So if you are an engineer, of course you have to go to a good lawyer to get the legal part drafted, and you can draft the engineering part. Likewise, you can get it done. So it's a draft, actually, just like a comprehensive document which shows the novelty.
That means in order to portray our novelty, we should take that what is called the expert advice and the guidance, otherwise we won't be successful.
Definitely your patent will get rejected. That's why they usually in Sri Lanka there are a lot of patents applications, but patents, of course, the amount of patents are getting registered are very few.
That is not because they are not giving opportunities for new creations, but yet the document is incomplete.
Documentation. Actually, European patents, WIPO patents, there are only, I think there are only about 2 patents. So that's the reason.
That means we have to prepare the document formally to portray our novelty, the industrial applicability,
Yes.
and the factors, so on and so forth. So then only it will become successful. So moving on to the other area, the what you call neighboring rights. So can you just comment on that, madam?
Yes, actually there are a couple of areas which are industrial designs and layout designs. They also can be protected under Intellectual Property Act. But when it comes to neighboring rights, of course, this is bit of a tricky area, because in artistic work, I mean the artist's world, all are combined. Now, if it is a dance choreographed by a dancer, choreography belongs to copyright. Dancers act belongs to neighboring rights.
Right.
So dancers have the neighboring right. Dancers have a performers rights. That is called performers rights. So for their performance, they can have a right, and also for the singers have the performers rights. Actors have a performers rights. Magicians, they have a performers rights. They perform something, and they have a right to performers. Modelers, they have a performers right. So whatever the performance you do, if somebody records it and publish and gain money, monetary, financial benefits, you can definitely go to courts and get yourself protected.
Is that, madam, using that particular video clip or photograph to in a certain manner, or can't we, like, if a certain performance is done, can't we that copy that performance and perform in some other thing to gain economical benefits? Will that be claimed?
That can be claimed. If you, I don't know how to. The thing is, like, I can't use the names. Now there was a particular actor. He was exactly imitated by another person in Sri Lanka. If you can remember. Right. Actually, that is called copying the performance rights. So that can be done.
Even the voice.
No.
Right.
Voice, of course, you can challenge, because usually one-to-one voices are not there. But the thing is, when it comes to now Mr. Bean. Mr. Bean, if somebody imitates Mr. Bean, that means the performance rights are violated. But the thing is, when it comes to Mr. Bean's market revenue, they are not claiming because of that. Right? The thing is, compared to us, they have earned their billions. So we don't have an unfair competition against them. That's the main problem. That's the main problem. They don't sue us. But it's wrong.
It's wrong.
Yes.
Although it's wrong, they are not suing because of that. They don't have any competition.
Unfair competition.
Yes.
So simply in this particular subject, competition should be unfair. Right, in order to take a legal action or any stern evidence should be built, unfair competition should be established. Right. So with today's program with regard to intellectual property, we exposed the copyrights, industrial arena, and certain neighboring rights to give you a fruitful idea about what is intellectual property, and we went a little bit in deep, and we're going to discuss further on this topic with regard to legal applicability, and we're going to wind up today's program. And thank you very much, Madam Aparajita Haridas, attorney at law and chairperson for Lanka Intellectual Property Organization, for joining with us with today's program. Thank you very much, madam. Thank you very much.
Right. So this is Law and Order, where we discuss current issues and giving you legal advices for you all to proceed to the future without letting you in trouble. So thank you very much, ladies and gentlemen, for watching this program. Stay tuned with Law and Order for more information, and have a pleasant day. Take care.